All right, good morning. I'm going to call the docket. When I call your name, please say here or present. If you would like a mask and do not have one, please ask court staff and one will be provided to you. Please maintain social distancing at all times. Make use of the entire courtroom, spread out, pay attention to your surroundings in the hallways, in the bathroom, common areas, and the elevator. John Davis. Justin Grubbs. Justin Richard Grubbs. Jesse Henry. Jesse Wagner Henry. Rachel Hicks. Tanya McBride. Stephen Gandy. Stephen Paul Gandy. Robert Paul Kane. Priscilla Rosales. Jeffrey Berman. Thank you, sir. John Carmona. Eric Atkinson. Mr. Atkinson, your attorney, Mr. Stevens, will be appearing online this morning, and he may be somewhat late. He's detained in another hearing in another county, but he. Okay, good. Antonio Lano. Mr. Stuckel, I see you online there.
Yes, sir.
Roderick Hunter.
Your Honor, I've been told that his route has been detained.
Thank you, Ms. Thompson. Gennaro Laredo Trejo. And Mr. Schmidt. Yes, sir. We'll take that hearing up promptly at 9:20, and we'll have our interpreter available, and we'll set Mr. Trejo up, I believe, in the jury room.
Can we go ahead and do that? I mean, do we have the interpreter online?
No, he'll be here. He'll be here at 9:20.
Do we have an opportunity to communicate with the interpreter?
Potentially, I don't know that we set that up. Did we set that up, Ms. Abraham? I don't think we did. However, whenever Mr. When Mr. Perales gets available at 9:20, let's check on his schedule, and if he doesn't have anything immediately after, perhaps we can let you communicate with him at 9:20 and then take it up as soon as you're ready.
I've spoken to
All right, is there anyone's name that I've not called that's in the courtroom? All right, counsel, do we have anyone that's ready? Mr. Stuckel, are you ready?
Yes, sir.
All right, Mr. Lano, if you'll make your way to the podium, please, sir. All right, Mr. Lano, can you see your attorney, Mr. Stuckel? He's appearing via Zoom here in this monitor. Can you see him at all?
Oh, yes.
Okay.
Yes, sir.
Mr. Stuckel, can you see your client, Mr. Lano, standing at the podium in the middle of the courtroom?
No, I can't.
Hey, can you wave your hand? Do you see him at all?
No.
About now.
No.
You on your phone?
I am.
You need to swipe left or right
Okay.
to get to another screen. And I believe that you may have muted yourself when you did that. There we go.
Okay, I do see him.
You seen? Okay. And Mr. Lano, just state your name so we can test the audio from Mr.
Oh,
Stoker.
Antonio Llano Jr.?
Did you hear that?
Yes.
Okay. All right. This is CR 2134. Mr. Lano is set for pretrial today. Mr. Stuckel, have you received all the discovery in the case?
We have, except for Child Protective Services records, we've received an excerpt on that. But the bulk of the CPS investigation, we have not received. There was a joint investigation as required by law under Article 2.27 of the Code of Criminal Procedure between CPS and the police. They shared records, they're fact witnesses. Their information is material to the case. I can't adequately prepare a defense without receiving all of those records.
And what's the status? Are those records being stipulated to and provided to the defense? Have they been subpoenaed? Have they been requested? What's our position on that? Have the CPS records been just provided to the DA's office? So, Mr. Stuckel, and did you hear Mr. Cox?
I did not.
And Mr. Cox, can you grab that microphone right here and just bring that to your table?
Whatever CPS records we have, Mr. Stuckel would already have access to.
And you believe that's Mr. Stuckel? Is that what you're referring to as an excerpt?
That's exactly. We're talking about a subdivision of the state with Child Protective Services, and again, a joint investigation between CPS and law enforcement. So the state should have the entire file. The fact that they don't is an issue with the prosecutor, meaning that the state would have to reach out and obtain those because they do contain information that's going to be critical to the defense, and we're entitled to see all of it. I have prepared a protective order that I've included with the motion for the court in this case to obviously keep those records confidential.
And so you have filed that motion with the clerk?
Yes, sir, I have.
Have you seen that motion, Mr. Cox?
I believe I have, Judge. I know. Let me see. Going through my email correspondence with Mr. Stuckel's office.
And Mr. Stuckel, while Mr. Cox is reviewing that, is your request just for the records produced during the investigation, the joint investigation regarding this one allegation?
Yes, sir, they are.
You're just not asking for any and all records?
Correct.
Judge, I've got 3 motions I received from Mr. Stuckel's office, not from him personally, but from his office. A motion in limine, a request for notice, and an omnibus administrative motion, but neither of which are requesting CPS records.
Now
I'm not opposed to providing them. I just have not been given a request yet for them.
we filed that motion back on August 19th of 2020, and
Okay, well, court served with a copy.
serve the state with that. So I don't know why he doesn't have it in his possession.
Court does see in the court's file motion to produce Child Protective Services records. There's a certificate of service, but I'm not checking was that served through e-file?
Yes, sir.
I'm just going to take a moment and read through your motion. Mr. Cox, do you want to take some time, and I can recall this case? You want to take some time to read that motion to see if you're in agreement with that or what the state's position would be?
Well, Judge, I mean, we're not opposed to providing CPS records. Now, I'm sure CPS will, try to quash any subpoena that's sent to them, and we'll probably end up having to have an in-camera review on those records. But I'm not opposed to reaching out to CPS and getting things started on our end.
I think that begs the question, are you going to require Mr. Stuckle to subpoena the records, or is the state going to request them from the department?
I will request them myself.
Okay. And so, Mr. Stuckle, you're not opposed to an in-camera review if that's the request of the department based on the statutory confidentiality of the CPS records?
No, we would not be opposed to an in-camera review.
Okay, so at this time, the court will grant the defense motion for the production of the CPS records. However, the court will entertain a request by the state for an in-camera review of those records prior to being released. So I haven't read your complete motion, but the court will grant the production of those records to the state of Texas, and the state of Texas will then notify the court of either its anticipated release of all records or their request for in-camera review. Does that satisfy you, Mr. Stuckle?
It does.
Okay. All right. Any other pretrial issues we need to take up at this time?
The rest of my motions are predominantly limine and administrative type trial motions. I don't believe there's any additional pretrial matters.
Mr. Stuckle, understanding though that you haven't received all of the CPS records in this case, do you anticipate the need for any evidentiary hearings, motions to quash, motions to suppress, anything of that nature?
I do not.
Okay. So what we'll do is we'll set this for hearing in November. I'm going to set it on November 24th for status of CPS record production at 9 a.m. That's an evidentiary day. And Mr. Stuckle, if you want to appear via Zoom, you may do so.
Yes, sir.
We'll just notify the court, so we'll have notice of that. The court would appreciate that.
Okay. Certainly.
And if your client, Mr. Lano, would also like to appear via Zoom, if you'll notify the court would grant permission to appear via Zoom at this time on the basis that it's the settings for production of records.
Yes, sir.
Okay. So we'll see everyone back here on November 24th. My bailiff is having your client sign a notice of appearance form with that date on there. We're going to give him a copy of it. And we'll resume this hearing on November 24th and see if that has given the state and department time to produce those records. And Mr. Cox, I would just ask that the state notify Mr. Stuckle in the court as to what it anticipates. If it gets the records well in advance of November 24th, if it's a request for in-camera or if it's just going to be a production of the records pursuant to this investigation, if you would just notify the court so that if there can be an in-camera review before then, the court could go ahead and get started on that. Yes, sir. All right. Anything further, Mr. Stuckle?
Nothing from the defense.
Okay. All right. Then, Mr. Lano, you're free to go. We'll see you back on November 24th. Thank you, Mr. Stuckle.
Okay. Thank you, sir.
You may. Yeah, as soon as I think that's Morning, Mr. Prowlis.
Good morning, Judge. How are you?
I'm doing great. Yourself?
Doing well, thank you.
All right. Let me see if I can get you set up here. Yes. Yes. All right, Mr. Prowlis, I believe that I am set up properly on my end this time, and this is Mr. Gennaro Laredo Trejo. And I'm gonna, let me change his name for you.
Wait a second.
All right, Mr. Prowlis, does everything appear to be working on your end? All right. This is, okay, great, thank you. This is cause number CR 20-177, State of Texas versus Gennaro Laredo Trejo. I believe we are set today for arraignment. I believe Mr. Richard Schmidt has been appointed to represent the defendant. And Mr. Schmidt, have you had an opportunity to meet with your client and review the indictment?
Judge, I did meet with Mr. Laredo Trejo this morning through an interpreter.
Sí.
I was able to explain to him the indictment. He relayed to me that he understood charges against him, that his name was spelled correctly in the indictment, and that we waive formal reading of the indictment and enter plea of not guilty.
Bear with me, Mr. Prowlis. All right, Mr. Prowlis. For some reason, I can't hear you now. Okay, I failed to swear you in. Let me go ahead and swear you in at this time. If you'll raise your right hand. Mr. Prowlis, do you solemnly swear that you will make a true translation of the statements of court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? And your name and license number? Thank you, and I apologize for skipping over that. All right, the court, having heard the plea of Mr. Laredo Trejo, enters into the record for purposes of arraignment a plea of not guilty. Court will set a pretrial in this matter on November 10th at 9 a.m. Mr. Prowlis, I would like for you to check for your availability that day as well before we finalize that date. Okay. And is there any time that's better for you than another after 9? At 9 or after? Okay. Then the court will set this for 9:20 a.m. And I do that time, Mr. Prowlis, because it gives me time to call the docket, take up administrative matters before we start hearing cases. Does Mr. Laredo Trejo have any questions for his counsel or the court at this time? And I believe I muted that so I didn't hear his responses in Spanish.
No, todo está bien. Todo bien.
Okay. And Mr. Schmidt, just for court's clarity, how do you anticipate communicating with Mr. Laredo Trejo during your representation?
Judge, I do have a translator available, several, just a matter of timing. I've spoken to Mr. Laredo Trejo about making sure complaints.
Okay.
And I've spoken to his brother as well.
Okay. And do you know if you've already been given access to the digital discovery?
I have, Judge, and I believe that the discovery is complete.
Okay. All right. Then if there's nothing further, then the court will set this for November 10th at 9:20 a.m. And the court will have Mr. Perales or his colleague available for translation on that day. You may. Thank you, Mr. Perales. And you can let Mr. Laredo Trejo know he is free to go. Thank you. Hope you have a great day. Just in the language interpretation.
Have your brother call. You want to do mana? You know what I mean? Okay. Okay.
There you
And then
are.
we're going to
Thank
give it
you.
in Espanol. It's in Espanol. You need to fill that out. Okay. And give it to the service.
There's a consequence of ending it. Morning, Mr. Hughes. How are you? You're on mute.
Okay. I'm ready now, Judge.
Okay, good. All right. This is cause number CR 20-26, State of Texas versus Robert Paul Kane. For the record, Mr. Hughes is appearing via Zoom today with court's permission. Mr. Kane is making his way to the podium. Mr. Hughes, can you see your client? And if you're on your cellular device, you may have to swipe over a screen or two to get different views. Mr. Kane, if you'll just raise your hand so that, and Mr. Hughes, that I believe when you swiped over, it also muted your device, so you'll need to unmute again.
Yes, sir, it did. Thank
Okay.
you.
Yes, and can you see your client, Mr. Kane?
I pay in your honor.
All right, Mr. Kane, can you see and hear your attorney, Mr. Hughes?
Yes, sir.
All right, good. You can put your hand in. All right, I believe we are set for a docket call today. What's the announcement from the defense?
Your Honor, we're ready. I have, like most everybody right now, been overloaded, and I have not had a chance to talk with the district attorney's office. They're going to review the file and talk with their complaining witness. So we're ready, but I don't know that we need a trial setting at this point.
Well, today would be the day that you would say we are either going to resolve it by plea agreement or we're requesting a trial, either a bench trial or a jury trial.
Well, Your Honor, if I have to make a choice, it would have to be a jury trial at this point.
And you understand that by passing today's docket call setting, the court may not entertain a plea agreement later if you and the state reach one.
Yes, Your Honor, I do.
And I'm just for my clarification, you indicated that you haven't spoken to the state about offers in this case or about anything?
No, Your Honor, the state was going to talk to the complaining witness. She has filed a affidavit of non-prosecution, and I believe they wanted to review all of the facts with her before they agreed to do very much of anything with it.
State, is there an offer on this case? Mr. Hughes, can you hear Mr. Cox?
No, Your Honor, I could not.
Is that microphone on?
I thought Mr. Hughes and I had discussed an offer last month here in court when he was here. He is correct about an affidavit of non-prosecution being on file. But I think we had talked about some sort of a lesser offense as a potential plea agreement in this case. Am I mistaken about that, Mr. Hughes?
I don't know. I don't remember that. We talked about a period of time or anything, but that would sound as if we could probably work that out okay. You're Judge, and I hate to be so equivocal about it all, but I've talked with my client about the possibility of a reduced sentence and from the current felony, and I believe that he is in agreement with it.
All right, Mr. Hughes, is it correct that you substituted in as counsel in August of this year? Is that correct?
Yes, sir, I sure did.
Okay. Yeah, my records reflect that this is about the 6th hearing after arraignment, and it's the first docket call setting. So what I'm going to do is I'm going to grant an additional docket call to give you and the state a chance to have final negotiations on this case. And so what that means is we'll reset this for hearing on November 12th at 9 a.m. and for docket call.
Yes, Your Honor.
On that date, I would expect to hear that all negotiations have been had, and either we're accepting a plea agreement or we are requesting a trial.
Yes, Your Honor. I will push this case to #1 on my concern list. And I apologize for the court for not having it all worked out by now.
I appreciate that, Mr. Hughes. And so the bailiff is having Mr. Kane sign a notice of appearance form. She's going to give him that. It's going to have that reset date of November 12th at 9 a.m. And then he's going to be free to go. You're free to
Thank you, Judge. May I be excused to them? Thank you.
Yes. You're welcome, Mr. Hughes. Have a good day.
You too.
Hello, Mr. Elliott. How are you, sir? I called your client. I don't believe he's here. Mr. Gandy? His bondsman is A. Springer Belbon. Please do. Mr. Ashmore, are you ready on anything? No problem. Ms. Thompson, any update on your client? No. Okay.
sir.
Yeah, sorry.
Ms. Rosales? All right, this is cause number CR 2191, State of Texas versus Priscilla Annette Rosales. You are Priscilla Annette Rosales, correct?
Yes, Your Honor.
Ma'am, if you will, raise your right hand. I'm going to place you under oath. You swear that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can put your hand down. Ms. Rosales, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Kurt Knoll. Are you pleased with his representation of you?
Yes.
Do you feel like you've had sufficient time to discuss your case with him, have all of your legal questions answered?
Yes, Your Honor.
Is there anything in this paperwork that you have signed and read that you do not understand?
No.
Mr. Knoll, do you believe your client to be competent today?
I do, Your Honor.
And you've explained to her all of her legal and constitutional rights? Ms. Rosales, you were originally indicted and charged by the Van Zandt County Grand Jury with a state jail felony offense of driving while intoxicated with a child passenger. However, it appears to the court that there is a plea agreement in this case in which, upon your plea of guilty, the state's recommending to the court that your prosecution be reduced to that of a Class B misdemeanor, which would carry a range of punishment of up to 180 days in the county jail and a fine not to exceed $2,000. Do you understand that full range of punishment? Yes. It appears that upon your plea of guilt, their recommendation is that you receive 180 days in the county jail, but they're recommending that the sentence be suspended and that you be placed on probation or community supervision for 18 months, that you receive a $1,000 fine, and the state is agreeing to dismiss an unlawful carrying of a weapon and a driving while license invalid in conjunction with your plea. And there was also an agreement to forfeit the weapon in the unlawful carrying of a weapon charge. In addition to that, you would have $270 court costs and $535 reimbursement fee, which would include your attorney fees. Is that your understanding of the plea agreement?
Yes, Your Honor.
All right, Mr. Knoll, is that your understanding of the plea agreement as well?
It is, Your Honor.
Ms. Rosales, to the charge of Class B misdemeanor driving while intoxicated, how do you plead? Guilty or not guilty?
Guilty.
Are you pleading guilty because you are guilty of that offense?
Yes.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court accepts Ms. Rosales' plea of guilt. Mr. Knoll, any objection to States 1?
No, Your Honor.
States 1 is admitted into evidence, and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Yes, Your Honor. Ms. Rosales told us this morning that her first name was spelled incorrectly in the indictment. So we updated the judgment to the proper spelling of her first name, which included both an S and a C. We would make an oral motion to amend the indictment to reflect that correct spelling, but the judgment is correct.
So the correct spelling is Priscilla.
Correct, Your
What
Honor.
does the indictment reflect?
It has a C, but not the S before the C.
In both parts of the indictment or just the body?
In both parts, Your Honor.
Any objection from the defense?
No, Your Honor.
All right, the court grants the state's oral motion to amend the indictment for the correct spelling of the defendant's name to be corrected to the spelling as reflected in the judgment. Anything further from the state? Defense?
Your Honor, CPS was involved in the case. I corrected Ms. Rosales in any certifications she received. She should get actions.
All right, Mr. Rosales, based on the evidence before the court will follow the plea agreement in this case. Court finds that there is sufficient evidence to convict you of the Class B misdemeanor offense of driving while intoxicated. The court hereby convicts you of that offense and assesses your punishment in accordance with the plea agreement. Court hereby orders you to pay your financial obligations of a $1,100 fine, $270 court costs, and to reimburse Van Zandt County $535 in reimbursement fees. Mr. Rosales, have you been on community supervision before?
No, just pretrial release.
And you have already signed your conditions of community supervision, so that indicates to me that you've read over those.
Yes.
And so you know what's expected of you and required of you.
Yes, Your Honor.
And do you understand that by way of this plea agreement, if the court places you on community supervision and you violate your community supervision, the issue of whether or not you were driving while intoxicated is no longer an issue before the court for the court to decide. The issue will be, did you violate the terms and conditions of your community supervision? And if you do, the court can revoke your community supervision and can sentence you up to the maximum 180 days in jail.
Yes, Your Honor.
Understand that?
Yes.
All right, Mr. Rosales, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with my bailiff. After that time, you're to report to the probation department through this door.
Thank you.
Yes, thank you, Mr. Knoll. All right, who are you ready on?
We're ready on Mr. Davis.
John Robert Davis, CR 20155. Set for pretrial today?
We're set for pretrial. We don't anticipate any contested pretrial motions. There's still some film and video to state. So I think it's been requested. I don't know if it's been put on DVD for us. May not need it, Judge. We have a clean recommendation of 3 deferred, $1,000 fine plus court costs and fees. We are in agreement with that offer, and we're going to ask the court to reset this on to come back and enter a plea. Sorry, Your Honor, the state has informed me that I did get. I don't think we're going to need. I don't anticipate that.
Are you available on Thursday, November 5th? Mr. Ashman?
Look at it. Calendar record, Judge. Yes, Judge.
All right, court sets Mr. Davis in for plea on Thursday, November 5th at 9 a.m.
Judge, may Mr. Davis.
Yes, Mr. Davis, we'll see you back on the 5th. Is Justin Grubbs here? We see Mr. Grubbs at all? Mr. Henry? Is Jesse Wagner Henry? Jesse Wagner Henry? You ready on Ms. Hicks?
I am.
Rachel Hicks, CR 20123. Separate pretrial today, Mr. Ashmore, go ahead.
We are set for pretrial. We're going to ask the court to reset us to the recommendation from Ms. Sales. This is her case. The recommendation is to defer $1,000 court cost fees and no opposition to early release after. We were successful in my mistakes. We don't anticipate that any problem. So this court reset it. Same thing for plea.
All right, there being no contested pretrial motions, the court will place Ms. Hicks on the court docket for the same date, November 5th at 9 a.m. for plea. And you've received all the discovery in that case, correct, Mr. Ashmore?
I have not, but again, Judge, Ms. Sales and I have spoken a few times about it, and I don't think I know what's going on downstairs, so I'm satisfied, and so is the state of this stuff. I don't believe that we're going to come back and draw our intent to enter that plea.
Are you involved in the CPS case?
No, I am not. Anything else from Ms. Hicks, or that she needs to do?
Thank you, Your Honor.
Ms. McBride, CR 2135, State versus Tanya McBride. Ms. McBride is also set for pretrial today.
She is, Your Honor, and this is a very early pretrial. just appointed Ms. McBride at our last setting. Although the state of Texas and I had all had a chance to visit independently. We don't have discovery, but we're kind of aware where the pieces are on the board. The state needs to talk to the victim, former employer. We can figure out what our negotiation will be over time to restitution. So we want to do the same thing, reset the plea, and give the state time to come here with what the restitution is.
So there is a plea agreement. It's just not complete because restitution is not finalized. You believe November 5th gives you enough time, Ms. Heisel, to communicate with the victim? November 5th, be about 3 weeks. You set it on the 24th.
24, that'd be appropriate. I think it would be good. I don't know if that's a contested hearing.
It's a contested hearing docket, but we can do a plea. All right, court will set Ms. McBride then for plea on November 24th at 9 a.m.
Say Ms. McBride, excuse me.
Yes, once she gets the yellow copy, court keeps the white copy. She's free to go. Is that all you have, Mr. Ashmore?
That is, unless, make up.
You may be. Thank you. Do you have anything this afternoon?
No, we can't get our, yeah, it's a civil case, so we're case in our table. Trying to make sure service is perfect, so I'll see you soon, but not this afternoon.
Not this afternoon. Okay.
Sorry, Judge.
Sorry. Doesn't hurt my feelings.
Well, I'm glad. But, we got a motion to new trial in Denton County. I'm making sure service is right.
Morning, Mr. Stevens. How are you?
Good morning, Judge.
Oh, I'm sorry. It looks like you're muted. There we go.
Can you hear me now, Judge?
Yes, I can.
All right.
We'll call your case in just a moment.
Yes,
Ms.
sir.
Christian just took a break. So as soon
No
as
problem.
she gets back, we'll call your client. He is here. So
Yes, sir. I spoke to him this morning. He was already there. Tried to explain to him that I was going to be on Zoom.
okay. All right. So
Thank you, Judge.
yeah, you bet. We'll check back with you in just a moment as soon as she gets back.
Yes, sir. Thank you.
You're welcome. Mr. Atkinson. This is CR 20-147, State versus Eric Ephraim Atkinson. Record will reflect that Mr. Bill Stevens, attorney for Mr. Atkinson, is appearing via Zoom today with court's permission. I believe we're set for arraignment today. Is that correct, Mr. Stevens?
That is correct, Your Honor.
And have you had an opportunity to review the indictment with your client?
Have not. He and I have discussed the indictment. He knows what he's charged with and the consequences, but he hasn't actually seen the true indictment.
All right. Stand by. Mr. Atkinson, I'm going to ask you to step forward, please. I want you to be able to stand close enough to where you can see the screen right here. All right. What I'm having displayed to you is the indictment in CR 20-147. The indictment in this case says that you are charged with a state jail felony offense of a violation of health and safety code, namely possession of controlled substance in penalty group 1, less than 1 gram. Mr. Stevens, does your client waive the formal reading of the indictment?
Yes, sir. We'll waive formal reading and enter a plea of not guilty at this time.
And Mr. Atkinson, do you see your name here? Is it spelled correctly? All right, court, and you can go back to the podium. Thank you. Court will enter Mr. Atkinson's plea of not guilty into the record, and we will set this for pre-trial. Mr. Stevens, are you available on either December 8th or December 10th?
The 8th would work better for me, Your Honor.
All right, we'll set Mr. Atkinson then for pre-trial on December 8th at 9 a.m.
Thank you, Your Honor.
You have the notice of setting form already, Mr. Atkinson?
Excuse me?
Do you have a notice of appearance form?
No,
Let me
no,
see. Let me see.
I don't
that.
have one, no, no.
Pull that out. All right, Mr. Atkinson, the bailiff is going to bring you this form. I need you to sign where it says defendant. I need you to write down your address and date it, and then we'll give you a copy. Okay?
Yes, sir. Yeah. Okay.
All right, Mr. Atkinson, you're free to go. All right, Mr. Stevens, you have that date, December 8th, 9 a.m.
I do, Your Honor. Thank you for your patience with me being late today.
You're welcome. Have a good day.
Appreciate it. Thank you, sir. You too.
Mr. Elliott, are you ready? I'm sorry, Ms. Thompson. Is your client here? let me take this up and we'll discuss that. All right, this is cause number CR 20-120, State versus Stephen Paul Gandy. And Mr. Elliott, we're set for pretrial today. Are there any contested pretrial motions?
There are today. We have discussed. My client did not actually touch the videos.
All right, we'll reset this for pretrial on December 8th. Do you have any scheduling conflicts on that date, Mr. Elliott? December 8th. On the 8th. What about the 10th? December 10th. Tuesday. What about December 15th? All right, court sets Mr. Gandy for pretrial on December 15th at 9 a.m. All right, and Mr. Elliott, I believe that Mr. Gandy has signed his conditions of pretrial release. Those have been provided to him. Is that correct? Okay. All right, so Mr. Gandy, with conditions of pretrial release, you're obligated to comply with those. A violation of any of those could result in the court revoking your bail in this case. You understand that? Revoking your bond. What I'm going to do at this time, Mr. Gandy, I'm going to order you to submit to a urinalysis test. So I'm going to have you go to the pretrial release, or to the probation pretrial release office. You can just come have a seat through this door, and they'll attend to that. After that, then you'll be free to go. Oh, that way. Go with Mr. Waddell there. Yes. Thank you, Mr. Elliott. I like that tie, by the way. I knew you would. Ms. Thompson, will you check with Mr. Nicholas to see if he's had any further contact with your client? All right, court call CR 27-3, Jeffrey Berman. Just come to the podium, Mr. Berman.
Yes, sir.
Are we set for plea today, Mr. Sanders?
Yes, Your Honor, Judge, we filled out the papers that Ms. Berman lives in Florida, and there were some issues that we're talking with probation about interstate compact. Basically, driver's license, showing residency. Be transferred. We can reset it maybe 30 days on a Tuesday. Maybe in December, if that were the first December.
Any objection from the state? Anything else changing about the plea, or it just has to do with interstate
It
compact?
just has to do with that. We got everything else.
So all the paperwork's complete, ready to go today?
Yes, yes.
Let's go off the record for a moment. All right, we're back on the record in CR 20-120, State versus Stephen Paul Gandy. Mr. Gandy, the court had you tested for controlled substances today on the basis of the court's order placing you on pretrial release conditions. It's been reported to me by the pretrial release office that you have field tested positive for methamphetamines.
Yes, sir.
Okay. So what I'm telling you now, Mr. Gandy, is that court's conditions of pretrial release are tied to the bond that you posted in this case.
Yes, sir.
Violation of those bond conditions will result in your bond being revoked and you being placed back into custody, the Van Zandt County Jail. You posted a $50,000 surety bond with a Springer bail bond, did you not?
Yes, sir.
You understand that today would be a violation of those conditions. Now, Mr. Gandy, I believe in fairness. When you walked into this courtroom today, you were not on conditions of pretrial release.
Yes, sir.
But the court has placed you on those at this time. Now I've admonished you that a violation of those will result in the court revoking that bond and putting you back in jail, and most likely doubling or even increasing it higher than the original $50,000. A continued violation of the court's orders will leave you sitting in the Van Zandt County Jail until you resolve your case. Understand?
Yes, sir.
I'm not going to revoke your bond today because I just placed you on these conditions, but I'm giving you this warning now. Every time you come back in here, if there's a violation of your conditions of pretrial release, we're going to have a hearing about it. And if I find that you violate, I'm going to send you back to jail.
Yes, sir.
All right? If you have a drug problem, you need to be working with Mr. Elliott now to address that so that you can resolve that issue at the same time you resolve this case.
Yes, sir.
Understand?
Yes, sir.
All right? So you're to report, you're to comply with every condition of your pretrial release. If Mr. Waddell calls you in and says, I need you here to drug test at a certain time, certain period, and you don't show up and you don't give that test, then that's going to be a presumed positive test.
Yes.
And the court will use that as evidence of violation of the court order. Do you understand that?
Yes.
Okay. So I've made myself clear, so I don't want any confusion. If you come back in here testing positive for methamphetamines or alcohol or anything that would be in violation of your conditions.
Chris. Yes, sir.
So we're clear. You and I are clear. Okay. And Mr. Elliott, I would suggest that you get a copy of that. Our pretrial release department will provide you a copy of his pretrial release conditions. As a courtesy, we'll provide that. So you're free to go, Mr. Gandy, with that warning. We'll see you back on December 15th. And between now and then, I expect you to be in strict compliance.
Yes.
Okay?
Okay. You see you, Judge?
Yes, thank you, Mr. Elliott. Appreciate you coming back on short notice. All right, bailiff. The court had you call the names Justin Richard Grubbs and Jesse Wagner Henry. The record will reflect that each one of these individuals' names was called at the 9 a.m. morning docket with no response. Their name has been called loudly, distinctly 3 times in the courthouse. Any response, bailiff?
No response to either name, Your Honor.
There being no appearance by either defendant, both receiving adequate notice from the court hereby issues a judgment nisi, alias capias, and issues new bail in each case at $150,000. All right, court's going to stand in recess until we have more information on Mr. Hunter's appearance. All right, this is cause number CR 20169, State versus Roderick Hunter. We're set for arraignment today. Ms. Thompson, have you had a chance to go over the indictment with Mr. Hunter?
I have, Your Honor. He said he understands the charges, his name is spelled correctly. For purpose of today's hearing, we hear a plea of not guilty, waive reading full indictment.
All right, the court will enter Mr. Hunter's plea of not guilty into the record. We will set this for a pretrial hearing. Are you available on December 8th or 10th, Ms. Thompson?
I believe we're available on December the 8th.
Okay, we'll set this for pretrial hearing on December 8th. And Mr. Hunter, where do you live?
Jackson, Mississippi.
Jackson, Mississippi?
Yes, sir.
And Ms. Thompson, if on the pretrial hearing date, if there's a request by your client to appear via Zoom for purposes of pretrial, then if you'll just contact the court and let us know, the court would grant Mr. Hunter approval to appear via Zoom on that day.
Just contact your office, let you know.
Just contact us and let us know,
Sure.
and the court will grant that today
Yes, sir.
based on him living in another state. Is Mr. Hunter on conditions of pretrial release at this time? Hang with us just one moment. I'm going to check some paperwork.
Excuse me, Your Honor. If you mean over there with the probation, I
Yes.
had went over there last month when I had left her.
Okay, so you do have conditions of pretrial release and you've been reporting over there?
She told me to come over there and see her when I leave here. When I came back this time due to the fact that I had stayed out so far out of state.
Okay. All right, just one moment. I'll have her check the paperwork for me. But you're telling me you have been reporting over there to the probation department?
Yes, sir. I went in the first day I left. You had me going there and they had something over there.
Okay. And that was the last time you were here?
Yes, sir.
When were you here? Because I showed that today was the first day for arraignment.
I was here last month on the 17th, I believe.
Okay. Let me.
I did receive an email, Your Honor, where he had appeared here, so that's probably true. That was the first day I got it going.
And it may just be my failure to recall. Yeah, we were set here on the 17th, so you must have been appointed that day and you weren't in court, and I reset it.
Yes, sir.
Okay. All right, yes, I see that you entered your conditions of pretrial release on September 17th, and you do have a copy of those, right?
Yes, sir.
Okay. All right, then we're set then for docket call. I'm sorry, we're set for pretrial on December 8th, and you are free to go.
Yes, sir.
I would recommend that you check in with them today to see if they need anything from you.
Yeah, I was going over there anyway. They told me to come and I leave.
Come here first. Good. Okay.
Yes, sir.
Appreciate you being here.
Yes, sir. Same building, right?
All right. Yes. Yes, thank you for waiting, Ms. Thompson. I appreciate it. All right, State, I believe that resolves us for the AM docket. Just have a handful this afternoon. Yes, ma'am. You anticipate you'll be in person or via Zoom? Person, okay. All right, we'll stand in recess till